Joining me now is Mark Heron, Senior Counsel for the Center for Reproductive Rights, which is suing Idaho on behalf of women denied emergency abortions due to complications. Mark, welcome. Give me a sense of the big picture here. What does this move by the Trump Justice Department mean for potential mothers in Idaho right now? And are you concerned this could extend to other states imposing their own strict limits?
So, Alex, this is really basic. This is about what happens when you have an emergency and you go to the emergency room and you need health care because your life or your health is in danger. For over 40 years, federal law has required hospitals and emergency rooms to provide the care that their patients need in order to stabilize them when their life or their health is in danger. What the Trump administration, DOJ's dropping of this case yesterday means is that the Trump administration is not going to enforce that federal law when the patient is a pregnant person and the care that they need is an abortion. Idaho has one of the strictest abortion laws in the nation. There is no health exception. And the way that the doctors and hospitals are interpreting Idaho's law is that they are only allowed to provide abortion care if a patient is essentially on the verge of death. They can't provide care to protect a patient's health. They can't provide a care even if they know that the patient may be at risk of death or some serious health condition if they remain untreated. And so federal law is what requires hospitals to provide that care in emergency situations. And the Trump DOJ apparently is saying, we're not going to interpret the law that way. You know, it's really ironic because President Trump keeps talking about, quote unquote, protecting women in sports, in locker rooms or in bathrooms. But when the woman at issue is a woman going to an emergency room and needs emergency abortion care, there is no protection for them.
That's an extraordinary disconnect that you just pointed out. So your case, Mark, against Idaho specifically, what's the goal? Are you confident you're going to win? And what are your biggest hurdles?
So our goal is to both get clarity and around the exceptions to Idaho's abortion ban and also to try to expand those exceptions. So as I mentioned, there is no health exception in Idaho's total abortion ban. There is only an exception if an abortion is necessary to save the pregnant person's life. And so without the injunction that has been in place for a while under this federal law that a federal court has put into place, Idaho hospitals were airlifting patients out of Idaho to states like Utah or Washington, where they could get the standard health care that they need because they can't get it in Idaho. We're going to see that continue without an injunction. Fortunately, the federal court yesterday did issue an injunction. The relief that we're seeking in our case would interpret Idaho law and the Idaho Constitution as allowing doctors to basically practice medicine the way that they were trained. And that means if abortion care is part of the necessary care for their patient to protect their life or their health, doctors should be able to provide that care without concern for being charged criminally or sued civilly or having their license taken away.
Does this get bounced back to the Supreme Court, do you think, Mark?
Well, the federal case that was in which the district court issued the TRO and that you mentioned St. Luke's, the largest healthcare system in Idaho, filed their own case. And so if the federal court there issues an injunction, I imagine that Idaho may appeal that injunction. It could make its way back up to the U.S. Supreme Court. Absolutely.